Okay, pleased to see you again. So we consider rest of cases titled Hornsby versus Allen and Withrow et al. Versus Larkin. Through the cases, you now recall upon the important rule, but actually very penetrating through the cases, disputing the context of a licensing system. So the due process of law is actually governing. So pre-termination hearing about suspension or revocation, particular revocation of licenses is important. In some cases, the court will see indispensable since the post remedy will not redress for the whole of a detrimented regular case. And in some cases, the point system may be sustained. In the state of Illinois, for example, the truck driver actually perpetrated a series of traffic offense, violation of traffic regulations, which is quite seen to threat the public safety in the highway waters. In that concern, we consider one important public agency about the concern, the adjudication branch of the National Highway Traffic Safety. Actually, a repeated violation of traffic regulation in that case led to several suspension. And in time period of suspension, the truck driver also violate the speed limit and cited as on that basis from the implementing agent, implementing officer, sorry. And actually, the state authority issued a kind of a precaution about its final measure, revocation. The condition was prescribed about 1 year period about the next violation. Then it means the state driver license would be revoked as a matter of system. So no termination hearing would be afforded. In that circumstances, the court would support the state agency since the context is fairly dispositive in sense, and as I've reminded about kind of a due cause from the public demand and kind of a challenges from the change of circumstances. So in that case, the public agency need to exercise a more competently is a adjudicative power, and automatic termination may merit in many aspects the good deals of a public administration. So in the first case, Mrs. Hornsby applied for license to operate a retail liquor store in Atlanta. Even though her background and the store's a proposed location met the licensing requirements, her application was denied by the City Council. No reasons were given for the denial. Mrs. Honey filed a lawsuit claiming that the denial without explanation constituted a violation of due process. Additionally, she claimed that a due process rights were due process rights were violated because either of two aldermen in the ward where the store was to be located could veto the application, whatever its merits. The district court dismissed the case as not falling under the 14th Amendment because it centered on a so-called a political question concerning the motives of a legislative body, and because no charge of discrimination was made. So, you consider some substantive elements expected from the law of due process. For example, ex parte evidence has to be excluded since the concept requires adversarial proceeding, kind of a judicial nature of a arrangement you consider. So, for example, the evidence has to be gathered from the witness who conduct an oath in the courtroom. So that would safeguard the kind of sure value in evidence long embedded through the practice of common law court. The court or the public tribunals would not base their decision on the kind of public source. So, for example, they would not use any evidence from internet sources that would plainly the law to be respected by jurors. And also the requirement is critical, since the right to cross-examine the witness need to be ensured for all the counterparties. An adequate notice and fair hearing is quite elementary. You consider in the fair practices of Anglo-Saxon jurisprudence. So two values and system are often equated with the essences of a due process of law. So at the outset, the court knows our disagreement with the district's court's classification of the challenged action as purely those of a legislative body. We do not conceive the denial of an application for license to be an act of legislation. So now the point is, as illustrated in the last session, between adjudicative and legislative phase. So how do you consider the denial in this case between two classifications? Although there is disagreement on the matter, we prefer the view that licensing proper is an adjudicative process. Thus, when a municipal or other government body grants a license it is an adjudication that the applicant has satisfactorily complied with the prescribed standards for the award of that license. Similarly, the denial of license is based on an adjudication that the applicant has not satisfied those qualifications and requirements. On the other hand, prescription of standards which must be met to obtain a license is relaxation, since these standards are authoritative guides for future conduct that derive from an assessment of the needs of community. A government agency entrusted with the licensing power therefore functions as a legislature when it prescribes this standard. But the same agency acts as a judicial body when it makes a determination that a specific applicant has or has not satisfied them. So what we now see is some distinct treatment about the due process of law concept. The APA still requires the process. For example, participation is important to create the rules, and so legislative function also depends on some concept which is not perhaps critical in comparison with the adjudicative phase of function. The code in this term is compelled to define how the state act is classed, as you consider is adjudicative one. Since licensing consists in the determination of factual issues and the application of legal criteria to them, the fundamental requirements of due process are applicable to it. Due process in administrative hearing proceedings of judicial nature has been said generally to be a conformity to fair practices of American legal system. So, as I said, the adequate notice and fair hearing are elements. And it is not proper to admit expert evidence given by a witness not under oath and not subject to cross-examination by the opposing party. So the idea is the deciding authority may not base its decision on evidence which has not been specifically brought before it. The finding must conform to the evidence adduced at the hearing. Furthermore, the Supreme Court has said that an administrative order cannot be held merely because findings might have been made and considerations disclosed which would justify its order. There must be such a responsible finding. So responsible finding is an invariable element in concern and concepts through the all respects of this kind of a meditation. Neither is the assertion the liquor may be a menace to public health and welfare a sufficient answer to Mrs. Holmberg's allegations. So now the state authority about licensing is very reprimand. The potential social undesirability of product may warrant absolutely prohibiting it, or as the Aldermanic Board has done to some extent here, imposing restrictions to protect the community from its harmful influences. Nonetheless, the court perceived still it would endanger the kind of prejudice. So some adequate process need to be afforded to the interest published addressee, in this case Holmesby. The dangers alleged by administrators do not justify depriving those who deal in equal or seek to deal in it of the customary constitutional safeguards. Indeed, the great social interest in the liquor industry makes an exceptionally a strong case for adherence to proper procedures and access to judicial review in licensing the retail sale of liquor. Judications on the basis of merit. The first step toward ensuring that these expectations are realized is to require adherence to the standards of due process, absolute and uncontrolled discretion invites abuse. It follows that the trial court must entertain the suit and determine the truth of the allegation. So, as you expect, the court commanded a legal standard need to be established, and procedural due process must be provided in the liquor store licensing field. So now you recall that judicial impartiality has two components. Decision maker must neither prejudge the case before they hear facts presented to them on the record, nor decide cases in which they have a personal stake in the outcome. It was for the latter reason that the Supreme Court struck down a method of licensing optometrists in Alabama in Gibson versus Burial. The next case, titled Withrow versus Larkin, addresses both components of impartiality. Notice particularly that the same people who investigate also make an important decision about the termination of a license. This phenomena is called a combination of functions. So, this term is now required of your attention about this problem, and actually that might well create the suspicion that the adjudicative body would not be fair or prejudices about the prior investigation, for example. So the investigative officer may also play a role as a member of a adjudicative organ about a revocation of medical licenses or other. How to consider? Previously, we have reviewed a kind of recusal system about the state and federal courts, and Supreme Court has been involved about what the fairness or kind of perhaps the situation raised in the case may well impugn the impartiality of a judicial decision makers. The political campaign has been serious tarnished to raise due suspicion about it. And the system has now virtually common over most of jurisdictions. We also have that institution and civil procedure. And also the court may slant on the cost and benefit analysis. Consider and to impose excessive requirements about the disciplinary proceeding and others. There might be lacking or insufficiency about the financial resources to respond with, and also a fiscal deficit for the government to afford extent of a adversary process in which it requires actually time and resources and workforce in burden, and also there are many aspects you need to consider. For example, the point system also involves a distinct situation. You consider the offenses are quite serial, and also the petition to request a termination hearing may be seen to increase merely the light of a personal attention. Actually, the court would assume quite a sufficient surmise about the consequence that be eventuated in the proceeding. So most points have been dealt automatically through the point system, and quite systematic about points of a police consideration. The statement is well grounded about its exposure of facts, and actually quite grasping through the occurrences of a period of time for the traffic violators. So there is actually no room for any substantive and meritable contention expected in the proceeding. Just personal attention would be stressed in the court's expectation and surmise. That would actually place one point to produce such outcome in litigation. And consider the case that the withdrawal et al. Versus Larkin. The state, in this case, we are concerned of a medical discipline board about state of Wisconsin. It passed a law specifying a certain criminal offenses for which a physician could have his license suspended. So Larkin was charged by the board with fee splitting, practicing under alias, and also allowing unlicensed physician to practice at his Milwaukee clinic. At an investigative hearing, Larkin's attorney was allowed to introduce evidence, but not to cross-examine witnesses. The board then notified Larkin they would hold a contested hearing to determine if he should have his license suspended. Larkin sought and obtained an order from the district court restraining the board from holding the hearing. However, the board held another investigatory hearing in which it found probable cause to start the process of revoking his medical license. A three-judge district court found that the procedure presented a substantial federal due process question and enjoined enforcement of the licensing statute against Larkin. And the board appealed. So the question was initially answered affirmatively about a combination of functions. And in its amended judgment, the court asserted there was a high probability that appellee would prevail on the question. Its opinion stated that the State Medical Examining Board did not qualify as an independent decision maker and could not properly rule with regard to the merits of same charges it investigated as in this case presented to the district attorney. The Supreme Court disagreed. So actually, the Supreme Court offers leniency in extensive terms about the professional decision making. So they would be reluctant to substantially alter any merits, point of merits, merely based on the procedural weaknesses. Considering a fair trial in a fair tribunal is a basic requirement of due process, held in Liu Murchison, decided in 1955. This applies to administrative agencies which adjudicate as well as the courts, as held in a Gibson case, decided 1973. Not only is a biased decision maker constitutionally unacceptable, but our system of law has always endeavored to prevent even the probability of unfairness. In pursuit of this end, various situations have been identified in which experience teaches the probability of actual bias on the part of judge or decision maker is too high to be constitutionally tolerable. So the rule would go in one dimension, and the actually holding need to be analyzed, varying with the distinct elements of a respective case. So most popular basis about recusal or other kind of a law on combination of functions perhaps would be a pecuniary interest in the outcome from the adjudicators, and in which he has been the target of a personal abuse or criticism from the party before him. Actually, the bias might be embraced, not determinatively nonetheless in this case, but how much do you assess the situation posed in this case to fit within this two elements? The contention that the combination of investigative and adjudicative functions necessarily create an constitutional risk of bias in administrative adjudication has a much more difficult burden of persuasion to carry. So just rule is plain, and actually that could be proven very hard. It must convince the realistic appraisal of a psychological tendencies and human weaknesses, conferring investigative and adjudicative powers on the same individuals poses such a risk of actual bias or prejudgment that the practice must be forbidden if the guarantee of due process is to be adequately implemented. Very similar claims have been securely rejected in prior decisions of this court. So actually, the court takes a long journey about inductive reasoning from the precedents, in which, of course, a prevailing practice, consider a precedent and also analysis to make them distinguished among another and reach the final conclusion. Long logic to create a rationale and law, which is actually sustainable through the common law traditions. The court has also ruled that the hearing examiner who has recommended the findings of fact and rejecting certain evidence as not being probative was not disqualified to preside for the hearings that were required when reviewing courts held that the evidence had been erroneously excluded. The Court of Appeals had decided that the examiner should not against it because it would be unfair to require the party to try issues of fact to those who may have prejudged them. But this court unanimously reversed, saying, certainly it is not the rule of judicial administration, the statutory requirements apart, a judge is disqualified from sitting in a retrial because he was reversed on earlier rulings. We find no warrant for imposing upon administrative agencies a stiffer rule, whereby examiner would be entitled to sit because they rule strongly against the party in the first hearing. And also the court illustrates the Social Security examiner case. He has responsibility for developing the facts and making a decision as to disability claims, and observe that the challenge to this combination of function assumes too much and would bring down to many procedures designed and working well for government structure of great and growing complexity. That is not to say that there is nothing to the argument that those who have investigated should not then adjudicate. The issue is substantial. It is not new, and legislators and others concerned with the operation of administrative agencies have given much attention to whether and to what extent distinctive administrative functions should be performed by the same persons. No single answer has been reached. Indeed, the growth, variety, and complexity of administrative process have made any one solution highly unlikely. Within the federal government itself, Congress has addressed the issue in several different ways, providing for varying degrees of separation from complete separation of functions to virtually none at all. For the generality of agencies, Congress has been content with Section 5 of the Administrative Procedure Act, which provides no employee engaged in investigating or prosecuting may also participate or otherwise in the adjudicating function. But it also expressly exempts from this prohibition the agency or a member or members of body comprising the agency. So, actually, the statute provides some basis, which is quite guideful and principled through the course. An exception would be deliberated about this case. It is not surprising, therefore, to find that the case law, both federal and state, generally rejects the idea that the combination of judges and investigating functions is denial of due process. Similarly, our cases, although they reflect the substance of problem, offer no support for the above proposition applied in this case by the district court, that agency members who participate in an investigation are disqualified from adjudicating. The incredible variety of administrative mechanism in this country will not yield to any single organizing principle. So what? How do you consider the possibility about erroneous ruling from a short procedure and others? So later in noticing the adversary hearing, it asserted only that it will determine if violations had been committed which would warrant suspension of appellee's license. Without doubt, the board then anticipated that the proceeding would eventuate in an adjudication of the issue, but there was no more evidence of bias or the risk of bias or prejudgment than in the very fact that the board had investigated and would not adjudicate. So, actually, the case raises a point of distinction from the previous cases, since the balancing of interests quite slant on the board. You can see the probability of erroneous ruling would not be great. So quite slight, and of course we should be alert to the possibilities of bias that may lurk in the way particular procedures actually work in practice. The process utilized by a board, however, do not in themselves contain an accepted risk of bias. So, quite untenable view that it would be unconstitutional for the board to suspend appellee's license at its own contested hearing on charges evolving from its own investigation. So the district court might be perhaps to err in simplification about understanding the precedents. So needs to actually expand points of a delicate points of consideration about varying nature of cases. In evaluating the widow case, you consider two ways in which the procedural posture differs from that in Cinderella and Gibson. These cases set aside final decisions that may have been affected by bias. By contrast, the withdrawal decision impacted an administrative proceeding at an early stage. And second, as Justice White points out, no specific evidence of bias was introduced. In reasoning similar to the later Horwick case, the court presumes that professional decisions are impartial, valid, in the absence of specific evidence to the contrary. How much difference should courts give to a licensing board just because it is made up of professionals who are presumably fair and impartial? And also consider the previous example about bar membership, admission to the state bar. And also consider the discretionary analysis of facts involving the case of driver's license. With its 1971 decision in Bell versus Person, the Supreme Court announced a significant application of Goldberg versus Kelly's due process philosophy in the licensing context. The case involved the decision by the state of Georgia to suspend a person's driver's license because he failed to carry liability insurance as required by Georgia law. The court ruled that the state was required to give the driver a pre-suspension hearing comparable to that awarded the welfare recipient in Goldberg versus Kelly. So consider also differences about the licensing field. What is a welfare institution and driving license. The court rejected the argument that the license is a privilege rather than a right, noting that drivers have an obvious interest, often a financial one, in the ability to drive, and that this interest qualifies for constitutional protection. The additional expense of such hearings did not justify dispensing with due process protections. Bell vs. Burson rejected the argument that Georgia could suspend the license without the hearing because the statute operated automatically. That is, required no findings of fact. The court observed the various defenses the driver might present at a hearing would make suspension unnecessary, including that the license holder was not reasonable for a traffic accident, was not responsible for traffic accident, and hence not liable for damages, or showing that the license holder had paid off a damages judgment resulting from an accident. So in this case, the liability insurance would not be deemed compulsory. There would be a due balance between the competing interests. But consider it's lacking about what a precautionary effect about any system to impose in general comprehension through the drivers and others. The state may be required of the high needs to make a system general and comprehensive without any specific consequence being premeditated. The same requirement would seem to apply to point system license suspensions and revocations. While seemingly automatic in application, point system decisions could involve a variety of disputed factual questions. So, the factual questions would be administered automatically without any interaction substantially or interview process between agency or the interested policy addresses. That would be point to be reserved about the system, so the extent and scope would be adequate in surrounding many factors about our consideration. This could the dispute factual questions could include convictions mistakenly counted against the licensee because of mistaken identity, clerk's errors in traffic code records that erroneously assigned points to the wrong licensee, an improper calculation of points, or failure to grant points credit properly earned. So the Supreme Court in some case refused to extend bail to point system cases. The court chose instead to rely on the hearing officials to make accurate decisions and properly exercise a discretion. This may be unjust to the driver, but as you read the case, Dixon versus Love, try to identify what obstacles this ruling might create in the effort to improve a traffic safety. So as I said, 39 states have a one-strike policy about a drunken driver. So quite systemic and generalized to bring any massive effect, which perhaps would not be disfavored by a American public. Actually, if fatal means the kind of the manslaughter, and even if there intervenes any intent, criminal intent or others, actually the kind of perhaps well equated with the kind of a murder in extreme cases. And most states allow courts to grant a temporary license for driving to and from work or school after the person convicted of driving under the influence of alcohol completes an initial mandatory suspension period. So actually, the criminal culpability is a classic notion we have learned in the criminal law class. You consider the Sewell would reveal quite that aspect if you are a criminal law student. The captain in Sewell has now been prosecuted based not on negligent conduct, but based on perhaps other theory, murder was equivalent to the second-degree murder in the Anglo-Saxon criminal justice system. So now the development of a capitalist society exposes quite evolutionary context of a criminal law theory. So a line between important concept and criminal culpability may be blurred in some cases. Of course, we have a classic theory about perhaps what have we learned? So for the review might be left for your later work. Non-action in some extreme cases may lead to worse concept for the perpetrators. The captain of Sewell quite egregious over the critical time about emergency, sinking the ship, and actually professionalism about seamen and kind of quite fell to the ground in the scene heralded by KBS News or others. And as I have Frontier, the case titled Dixon versus Love, reveals the kind of a perversion of point system in actually this period of a traffic offense has led to some terminal measure from state government. A truck driver had a license suspended by the state of Illinois after he was convicted 3 times within a 12-month period of various traffic offenses. When he was convicted a 4th time of driving with a suspended license, another suspension was imposed. Several years after both suspensions had expired, Love was convicted twice more for speeding and cited for a 3rd speeding charge. While he was waiting to resolve the 3rd speeding charge, Love received a notice from the state informing him that his license would be revoked for over a year if he was convicted of 3rd violation. As it turned out, he was convicted and his license was revoked without hearing, pursuant to Illinois law. The law as written did not provide for hearing until after the suspension had already taken effect. Love challenged that law and the district court agreed with him. The case centers on Section 6-206 of the Illinois driver licensing law. The section is entitled Discretionary Authority to Suspend or Revoke License or Permit. It empowers the Secretary of State to act without preliminary hearing upon a showing by his records or other sufficient evidence that a driver's conduct falls into any one of 18 enumerated categories. Pursuant to his rulemaking authority under this law, the Secretary has adopted administrative regulations that further define the basis and procedures for discretionary suspension. These regulations generally provide for an initial summary determination based on the individual's driving record. And also a point system has been instituted in this province of traffic policy, perhaps from the law created by a secretary, not directly from the statute. One of the statutory enumerated circumstances justifying license suspension or revocation is conviction of 3 moving traffic offenses within a 12-month period. This is one of instances where the Secretary, by regulation, has provided a method for determining the sanction according to the driver's accumulated points. So, in some point, the Secretary has limited his broad statute discretion by an administrative regulation. The regulation allows suspension or revocation where sufficient points have been accumulated to warrant a second suspension within a 5-year period. So actually, regulation serves the efficiency of a public administration in general terms. Nonetheless, that also limits the discretion, leniency to be productive or effective against challenges of others. The field officer may be situated in a best position about the risk and challenges from. Nonetheless, it is effective for the kind of ideas we expect: stability, predictability, legal stability, and predictability. Section 6-206 requires the Secretary immediately to provide written notice of a discretionary suspension or revocation under this statute, but no prior hearing is required. Within 20 days of receiving a written request from the licensee, the Secretary must schedule a full evidentiary hearing for date as early as practical in either Sangamon County or Cook County as the licensee may specify. So we actually arrive. Well, it is clear that the due process clause applies to the deprivation of a driver's license by the state. It is equally clear that a licensee in Illinois eventually can obtain all the safeguards procedural due process could be sought to require before a discretionary suspension or revocation becomes a final. The private interest affected by the decision here is the granted license to operate a motor vehicle. Unlike the Social Security recipients in Algiers, who at least could obtain retroactive payments if their claims were subsequently sustained, a licensee is not made entirely whole if a suspension or revocation is later vacated. So to consider the consequence from the absence of a pre-termination hearing, between two licensing systems. It's actually you may consider this kind of a concern, and also a aesthetic in logic and metaphor about a preliminary injunction or any temporary measure to stall the current status of a decree or any orders. Then we consider the aftermath about this consequence from what arrangement would be proper in some way. That is also one factor in subtlety about the result of this case, perhaps. The Illinois statute includes special provisions for hardship and for holders of commercial licenses, but those most likely to be affected by the deprival of driving privileges. We therefore conclude, according to the court opinion, that the nature of private interest here is not so great as to require us to depart from the ordinary principle established by our decisions. That something less than an evidentiary hearing is sufficient prior to adverse administrative action. So I also consider the expected character of a post-termination hearing. For example, the kind would be a substantial disclosure would be slim. Merely the case reveals in other indication, and perhaps a personal attention would be employed about his detriment. Giving licensees the choice thus automatically to obtain a delay in the effectiveness of a suspension or revocation would encourage drivers routinely to request a full administrative hearing. Then substantial public interest in administrative efficiency should be impeded by the availability of a pre-termination hearing in every case. So it will require exhaustive resources, actually quite effective in terms of cost and benefit viewpoint about. So the court perceived that the public interest present under the circumstances of this case are sufficiently visible and weighty for the state to make it a summary initial decision effective without a pre-decision administrative hearing. And also, I advise to think about what actually quite a so-provoking article about a response from a respective state after the impact of this love case. The article was titled "Due Process and Driver Licensing Suspension Hearing. What do the states do after love?" Prepared by Georgie Brand, and featured in the Journal of Administrative Law Review in 1979. In his argument, the implications, what they delineated in detail, and in quite important points by court, are very not simplistic. For example, we may not tell it is correct that the point system would legitimate the general absence of a procedural requirement or procedural safeguards, and also the case do not the case is not seen in the holding that the state government have made more extensive provision of a process to protect the interest of deprived parties. After the case, for example, NHTSA study made a number of recommendations for the upgrading of nation's driver licensing agency hearing authority. 10 of the more significant ones are, let us read through the items. For example, first, that the author to withdraw the driver license and to conduct driver license hearings be vested with the administrative agency responsible for issuing and controlling driver licenses. The state legislature delegates sufficient authority to driver licensing agencies to support the conduct of these hearings and the subsequent administrative decisions concerning license withdrawals. Third, the Administrative Procedure Acts be adopted and made applicable driver license withdrawal proceeding. That an independent unit responsible for conducting trial-type hearings be established, and others in point. And particularly, need to be shared about the very advanced paradigm in purview. For example, training of experts to be individualized against the particularities of a various drivers is highly recommended. For example, since have some point of knowledge about postmodern context of expansion through the terminals of quite the general and abstraction would be in response to mass production and mass consumption society, or how to consider. Actually, the support could be seen afforded to provide more concerned deals or response against the harms and potentials of risks now present in this community. Consider, however, in adversary evolution, several case, we now state what the government may be seen to revert to the 1980s one. If we are disposed to consider the safety level of nation. And also I mentioned, for example, the general nature of a criminal culpability. And now the human agents and or many arrangements, public and private, are quite dispositive and actually a diversion over not easily be generalized. For example, the mental state of a criminal would not be simplified into the concepts in which would have actually possess high quality to consequential in some a major aspect. Nonetheless, we have many elements to see the nature of humanity in more diverse ways. In what does it mean, for example, the human activities on online space or others, and also the fundamentals of society may influence the personhood in other ways, then could it be illegitimate to ascribe any severe responsibility to its person alone? What is affected from the environments or the kind of structure of community in a very foundation? Can we see most factors of capability from person? The structure is quite persistent and make the person illegitimate in many cases. So the juror's role would be expected to exercise a more developed concept in adaptation with changing circumstances. And also for example, the states need to develop an independent, qualified driver licensing agency hearing officer unit with the authority to handle all hearing requirements, both formal and informal. This would include rendering decisions and issuing orders in point system and other license suspension actions. In support of this unit, states should adopt the following 5-point program: a notice to drivers of pending license withdrawal action, and a statement of reasons and due process right. Second, an opportunity to termination hearings in point system suspension or revocation cases. Third, pre-termination hearings before hearing officers who do not also serve as driver improvement analysts, forced employment of hearing officers who occupy senior level positions in the driver licensing agency, and fifth, hearing officer training in due process, in traffic law and adjudicate procedures, and driver behavior and highway safety. So actually, we have recognized that the agency has a principal charge to write the law or write the rule, how to create the rules, and the context need to be visited in combination with the dimension of implementation. Yes. And also of the class progress, we have been exposed to kind of many elements about agencies writing of the rules. Yeah? For example, the substance of rules and the reasons for rule making has been one point. We begin to understand the administrative agency. And the process of rule making is not exhaustive by merely referring to the administrative law, APA and others. There are many important particularities which may look into the process, to the final end outcome of the specific policies, the process and substance. And the core elements of rulemaking was illustrated in coverage from the APA, Information, Participation, Accountability. And I have now like to recall on that point. And information might be related, increased legal requirements. And in previous paradigm, the agency would quite emancipated from any strict binding regulations when they gather information and others. The context would be improved, and with a provision of a scope of statute. And also participation actually is supposed to issue a democratic rule. Expanded opportunities mandated by law would increase the persuasion of rules and effective implementation through the scope of regulated communities. And also we consider mechanisms of accountability. I have accepted one picture, which is a logo of United States Government Accountability Office, what we call GAO in abbreviation. And the agency is now responsible comprehensively to the value we now expect about public administration, accountability of government, United States government. And actually, the logo would arise from my point about timeliness of a rule making, and in the printout delivered in last class, you will now conform the graphics about what a rules in progress and in what actually final end product, in the number of final end products, and the agency might progress on the programs or initiatives what they assigned by Congress, and the number of programs or rules would vary according to the respective agency, and EPA perhaps would be EPA and OSHA, perhaps a principal most notorious organization about abundance of rulemaking kind of activities, and other how about the civil aeronautics board? Yeah? So figure 3-1, a Federal Aviation Agency have a 21 in number, which were finalized within 24 months of close public comment period, and 5 in number would indicate the finalization from 24 months up to 60 months after close of public comment period. And what is number 3? It indicates that 3 rules have been finalized from 60 months up to 120 months after close of public comment period. What does this mean? So actually, timeliness have varied, and worse in some in concerns of some agency, FAA. What is most underproductive agency in this case? NHTSA has 6 to 1 respectively about this classification. 6 comes firstly in the first category, 2 and 1, and EPA, FDA, and APHIS. APHIS is the most readier to create rules in most earliest possible time. No number would be identified for later 2 classifications, and 19 rules have been produced in earlier time consequence. So timeliness would be a variant about the merits of its policy response, and actually effect could be measured in that point about implementation and any desired achievement of policy intended policy goals or others. So GAO is a very consequential institution through the concerns of public policy and administration in the United States. And actually, we, the group of citizens, are highly attentive to the accountability of government. You consider a key theme, perhaps. And also, we instituted separation of power principle and actually managed the tripartite system of government about check and balances, judicial review, as we have learned, assumed an important expectation about rule of law, and the accountability would come in rigidity in the concept. And also the Congress is a principal organ elected democratically from our from the public election, and often represent the political expression of nation as placed in the 4th chapter of the United States Constitution. And the kind of concept is actually interactive when you consider the process of rulemaking. And we also surveyed how the APA model has changed. And piecemeal less nature of response in legislation was quite conspicuous about practice of United States, as I've illustrated about public measure and others. Nonetheless, APA provides a comprehensive modality about state government and also directly applicable to the federal governments. Federal governments. And now we witnesses some important changes about exceptions, exemptions, evasions. And also we considered the stages of rulemaking in subtopics, as I have briefed in earlier classes. And we consider the management of rulemaking, which is, of course, substantial, and in some cases, from the delegation of a congressional act and presidential management is actually immediate to initiate or undertake a supervisory role to monitor and check through the realities of a policy delivery and others. And also management on the agency level has implications, which is practical and perhaps consequential for the regulatory community in any binding terms or others. And also we are required in further review through the subsequent class for participation in rulemaking and oversight of rulemaking. This issue have been surveyed in the previous class, which, however, will need some further revamp about this class purpose. And as I recall, the basic purview had to be in reminiscence about what a parent agent theory and bureau dominance school have have structured our general understanding about a paradigm of a public administration in the United States. And the next class would be furthered on that point, which would be general and in wider coverage about. Okay, I exceeded the agreed time of what actually. And that will be all for this class. Thank you for your attention.